Good afternoon. How's everyone doing?
Good.
Hi.
Good afternoon.
Hi there. Do you need a breakout room or are you ready for the judge?
Uh,
Um, I don't really think I do. Do you?
no, did you send any materials?
I didn't. I was supposed to get some materials from you. I was
I
under that.
sent everything.
To whom? To me?
I sent them, filed them with the court, and according to the court, they were CC'd to you.
Do you want a
Uh,
breakout room?
Yeah.
sure.
Good afternoon, Mr. George.
Good afternoon. How are you?
I'm good. How are you doing?
Working on my third cup of coffee, so I'm getting
Oh,
there.
uh-oh. Hopefully it's helping. What case are you here for?
I am here for let me get the full
Are you
case
here for
caption for you.
McLaren?
No, for Baldwin. Corey
Baldwin.
and
Okay.
Tiara Baldwin, with Park Estates.
Okay. That's at 1:30.
Yeah, I know. I was
Okay.
just hoping that if I showed up a little early, maybe I'd get a chance to speak with someone, so I can just
Okay.
hang out for a bit.
All right. Sounds good. All right. Thank you.
Yep, thank you.
This is 2302264 LT, Park Estates versus Kenda McLaren. May I have your appearances, please?
Good afternoon, Your Honor. Laura Kirby on behalf of Plaintiff Park Estates.
Excuse me, and Your Honor, Danette McLemore appearing on behalf of the defendant Kenda McLaren, who is also present on the Zoom.
Thank you. Today was the day and time scheduled for the hearing in this matter. The parties have had the opportunity to speak. How are we proceeding this afternoon?
Your Honor, I did have a chance to speak to Ms. McLemore. She did inform me that she had filed some abatement forms with the court, along with the proof of service. However, my firm has not received them. I don't have anything in the file, nor does anyone at the firm have any knowledge of receiving them in the mail or via email or anything like of that sort. So that's one thing. We've been here since, I believe, late October, early November, because of some certain repairs that need to be made. And we have been working diligently to get those repairs made. On January 4, the defendant was notified that the repairs have been approved by the contractor, but again, because hold on one second. I'm in court, one second. I apologize, Your Honor. However, they did notify the defendant that it's going to take about 4 to 6 weeks for the repairs to be made to the home. And again, I don't have any documentation in front of me regarding the abatement, but at this time, Your Honor, I don't believe defendant is entitled for any abatement of rent because the repairs are not substantial to the point where she is out of the home or she feels like she is unable to use the home for what the purpose of the home is supposed to be. These are repairs that are minor. And I have documentation if that is what you would like to see regarding the approvals of these repairs.
Ms. McLemore?
Yes, Your Honor, when we were in court the last time, I was told at that point that there had been an approval for repairs to be made. Some of these things are things that the defendant has notified the landlord of Mr. Park Estates for over a year ago. And they have yet to be done. According to the information that we just received from the manager, a maintenance person reached out to her on January the 4th to say that things had been ordered and that there had been approval and that they would contact her for repairs, but they've not been done. I did file, I e-filed photographs and documents to the court on the 17th of January. I think your judge, Your Honor, indicated at that time that it would be very helpful to send the things prior because it takes time with the in-file system. So we did forward documents to the court on January the 17th, and hopefully those things are in the file. And according to the in-file, they also forward those documents to plaintiffs or to any other parties at that time. And Ms. McLaren is present, and certainly she can testify to this, to the things that I've just mentioned.
If I may, Your Honor. I know that Ms. McLemore stated that Ms. McLaren has been reaching out to the staff since over a year ago, but while she is correct in the sense that she has reached out a year ago, that was a different matter. This isn't the first time that Ms. McLaren is in court for non-payment of rent, wherein she has raised certain repairs that need to be repaired. And this time last year, we were in court for the very same reason, and we ended up doing a payment plan for her non-payment and then did do those repairs. So these repairs are entirely different than what Ms. McLemore is stating needed to be made last year. These are ones that we have just been made aware of when we filed this lawsuit for non-payment of rent back in November.
And we 100% dispute that contention, Your Honor.
The on-base system shows that their photographs, emails received, they're photographs of the unit emails from Ms. McLaren to, I believe, the property received by the court on January 17th, sent to Mr. Levine's office on the 17th at 3:44 PM. Ma'am, are you saying you didn't receive them and no one else in your firm received them?
That is correct, Your Honor. As to the extent that I can testify under oath, I have not received them, and if anyone at the office had received them, it would have been in the file for today's hearing.
I'm looking at the proof of service in the on-base, automatically generated by on-base, that shows that these documents were sent to JELEVINE@SwisstechLevine.com.
Correct, Your Honor. That is Jarrett Levine's email handle, and I can double check with him if you'd like. But as I'm stating, as I'm looking at the file now, I have not received anything, nor have I received notification from my file like I usually do.
And and if I may say, Your Honor, I believe at the time we were in court, you did recommend that we send things at least a week before because it was a delay in things being inputted into the system. And so I believe that was information that the court instructed at the time we were here, which is why, again, I did send those things on the 17th. And again, according to the proof of service, they were sent to opposing counsel at that time.
Yeah, and Your Honor, I do
No,
apologize.
no. We're not going to go back and forth. Here's the thing. This case was scheduled for hearing at 1 o'clock. It's 1:17. All we've talked about so far is that there was a prior case and documents weren't received. I can only go by what's in the court system, and on-base shows that these documents were forwarded to the attorney of record, whose name would have appeared on the filings from October the 16th, I believe. That being the case, are we prepared to have a hearing on this non-payment of rent case this morning, Ms. Korabi, or are we proceeding some different way?
Your Honor, we can proceed by hearing.
You have all necessary documents and witnesses, ma'am?
Yes, Your Honor.
Ms. McLemore, same question. Do you have all necessary documents and witnesses?
Yes, Your Honor. I would just like to say that any documentation or any exhibits that would have been, that are planning to be submitted by the defendant, Your Honor, I have not had an opportunity to see it all. So I believe that I would be a little bit of a disadvantage, and I have not seen them. And again, I don't think that there was any assertion that they were submitted to the court.
If I may, Your Honor.
Yes, ma'am.
That is correct. At the last hearing, in my notes, I may have misunderstood, but I always thought that I was to present the evidence today for the trial. However, if Ms. McLemore is interested in adjourning this matter so we can exchange these properly, I can. I have no problem sending these to her.
What I would have said on the record was to send them on base a period of time before the hearing, because it takes the civil staff a day or two to get to it, to upload it to the file, and I review these files a day or two before the scheduled hearing. So the only things that were in the file were the documents that were submitted by Ms. McLemore. So I wasn't sure, I can't be sure if you intended to supplement the documents beyond what was attached to your summons and complaint. So if it's your request to adjourn so that you may exchange documents, the court is happy to do that.
Well, Your Honor, I have no problem, but again, I don't think Ms. McLemore disagrees that the only evidence that I have exhibits are the fact that they were approved, and I don't think she disagrees with the fact that these repairs have been approved. Otherwise, I don't really have any other evidence to present to the court.
Well, to say that they're approved, the issue is that they're not done. And some of the photos and some of the things are not, opposing counsel has indicated that they're minor. I think that is certainly a matter of fact for the court to determine. I don't think that that all of those can be determined to be minor. And again, she has communicated with the landlord. We've got evidence that she's communicated with the landlord. So, Your Honor, you're at this point in time, if there is if there is an adjournment in this manner, then of course we would come back at that time. But the information that we have submitted to the court, that is the information that we would go forward with today.
I was prepared to give you a date next Wednesday, but I can't tell from the response if that's helpful. Ms. Korabi, you're saying that you don't want the adjournment?
No, I'm good with the adjournment. I would rather, first of all, try and find the forms that were submitted to the court. I'd like to look at them. And then I will send over whatever I have to you and to Ms. McLemore today.
Mary Ann, would you look at the 31st and see if we have something in the afternoon? Are both of you available next Wednesday?
Your
Yes.
Honor, I would need to, double check.
Let me look.
You would need to what? I'm sorry, Ms. McLemore.
I'm sorry, I just need to check my calendar very quickly.
Absolutely. I'm looking at the same time next Wednesday if you're available.
You're good, Judge.
Yes, Your Honor.
I'm sorry, what's wrong, Mary Ann?
No, I'm sorry, that was garbled. You are good.
Oh,
Yes, Your
thank
Honor.
you.
Yes, Your
The
Honor.
31st at 1 p.m. The court did receive, Ms. Karabi, I'm concerned that if the on base is showing that they were forwarded, if you don't have them, how to get them properly to you. And then if there's
Yep.
something else beyond what was attached to the summons and complaint, if you would submit it through on base and share with Ms. McLemore, we'll be prepared to take it up next Wednesday afternoon.
Not a problem, Your Honor. I will file it that way. And if Ms. McLemore, if you could just email me, I know you have my email. If you could just email me what you sent over to the court.
Sure.
Thank you.
Anything else, Ms. McLemore?
No, thank you, Your Honor.
Thank you. Ms. McLaren, I will see you next Wednesday afternoon at 1 p.m. You have a good afternoon.
Thank you.
Is Mr. George here for the Baldwin matters?
Yes, ma'am.
Ma'am, do you want to, have you spoken to Mr. George this afternoon? Ms. Corabi?
Oh, no, Your Honor, I have not. I did not know they were being represented by Mr. George.
I didn't either until he logged on about 10 or 15 minutes ago. Happy Wednesday, right? It looks like he's meeting with his client, so as soon as he makes himself available, we'll try to get you connected.
Okay, thank you, Your Honor.
Thank you. Mr. George?
Yes, Your Honor.
This is 2302101 LT. This is Park Estates versus Baldwin and Baldwin. Your appearances, please.
Laura Kruger, Your Honor, on behalf of plaintiff.
Good afternoon, Your Honor. George of Lakeshore Legal Aid on behalf of Tiara and Corey Baldwin. I was just retained on this matter this morning, so I haven't had a chance to file an appearance yet, but I will do so very soon here.
Mr. George, I understand that you were just retained this morning. We appeared, the first hearing in this case was on November 29th. The case was adjourned. The defendants had alleged that they had retained counsel. At the next date,
I apologize, Your Honor.
Thank you, ma'am. And then the most recent time we appeared, there was a conversation that there was a payment that was at issue, had not either been properly credited or properly applied. You've had the opportunity to speak to the attorney for Park Estates this morning, this afternoon, other than filing the appearance. Is there anything else we need to address?
I don't believe so, Your Honor. We have agreed to the terms of a consent judgment, so this will be resolved today. As far as that payment that was brought up last time, we're not disputing that for the purposes of our consent judgment today, but I will be working with the Baldwins to see if they can get some proof of that payment so we can get an adjustment on the ledger. So that
What are the
I
terms
guess-
of, I'm sorry, other than that, what are the terms of the consent judgment, sir?
So Ms. Karubi, correct me if I'm wrong, but the current balance as of today is 8,363. And did you say 66 cents?
No, it's $8,360.63.
Ah, there we go. Thank you, Ms. Karubi. 8,360 and 63 cents. That will be with a pay or move date of February 12th, including February's rent. And then again, we're going to be working with the plaintiff to see if we can get some adjustments on that amount.
And does that 8,360.63 include court costs?
Yes, Your Honor.
Thank you. Were there any other terms that needed to be included in this consent judgment, Ms. Karabi?
Yes, Your Honor. The defendants have also agreed that February rented fees shall be paid by February 12th as well.
Yes, ma'am.
And
Mr.
there
George?
was, yes, there was actually two things further. Number one, the plaintiff has agreed that if defendants pay or vacate by that date, the 12th, they will set aside this judgment upon request. And then the other thing that I'd like to note for the record is that there are some repair issues. We've chosen not to litigate those today, but I have made Ms. Karubi aware of those. And so we're going to be looking for those to be addressed going forward as well.
And that is correct, Your Honor. But if I may, Mr. George, I actually am not authorized to consent to the motion to set aside the judgment if they pay in full or vacate. But Ms. Kobish is here, so if she does agree to that, then yeah, we can put that on the record and we can include it.
Ms. Kobish?
Okay, so that includes, like, so you guys were saying they pay everything, including February's by February 12th, or they vacate?
Correct. And if they do that, they satisfy that judgment, do you agree to set aside that judgment?
Yes,
Thank you.
you're welcome.
Anything else on behalf of either side?
No, Mr. George, I did send you the copy via email. If you just want to sign it, we can get that submitted today.
Certainly, I haven't seen it pop up yet, but I will get it back to
Okay.
you as soon as I can.
Thank you. If there's nothing else, I will await receipt of that signed consent judgment. Mr. and Mrs. Baldwin, good luck to you. Everyone have a great afternoon.
Thank you, Your Honor.
Thank you very much. Thank you, Ms. Karubi. Thank you, Ms. Kobish. And
Thank
to
you.
the Baldwins, I'll follow up with you in the next couple of days here.
And then Mary Ann, our next case is at 2 o'clock.
Okay. do you need to go into a breakout room? Do the parties need to speak to each other?
No,
Okay,
Good afternoon. No, we are not going to, it's not
Okay.
needed.
okay, thank you.
Yep.
I gotta do this court thing, son. Love you too.
This is 2301767 LT. This is Brent Shea and William Asper versus all occupants. May I have your names for the record, please?
Good afternoon, Your Honor. William Asper.
Good afternoon. My name is Brent Shea.
Good afternoon, Your Honor. My name is Robert Kilgore.
And Brooklyn Manchewski.
Thank you. Today is the day and time set for hearing in this matter. When we were last here, I asked that the parties submit anything that they wanted the court to consider during the course of this hearing before today's date. The court has received filings from the defendants in this matter. Mr. Asper and Mr. Shea, are the plaintiffs prepared to proceed this afternoon?
We are, Your Honor, we are prepared. Neither of us received anything from the defendants, though. So I would ask that be stricken. Now, I have, I was stopped by, I dropped off information to the court and I dropped off information, my evidence to the defendants as well.
Dropped it off when to the court, Mr. Asper?
I dropped it off, let me see the date. I dropped it off on January 3rd, which I went to the defendants, the location, where I dropped it off there as well. This was
Mr. Asper, Mr.
Yeah.
Asper, that's my mistake. I thought this was from the defendant. It's from you.
Oh, no, correct. Yes. Okay.
Okay.
Yes, Your Honor.
Oh,
Ms.
Your Honor, I'm
So we're
sorry.
ready to proceed.
So the stuff that we have, Mr. Shea already has. It's like text messages and things of that nature. But I couldn't figure out how to do it with the court. I was hoping that I could share the screen or something like that in here if we need to.
Your Honor, I ask that whatever they have, I mean, it's not relevant for today. You gave everyone time.
No, Mr. Asper, the court makes a decision if something's relevant or not. I asked that things be filed beforehand so that we have the opportunity to review them. It makes it a little bit easier for us to get through the hearing, but that's an aside more than anything else. Are the defendants ready to proceed with the trial in this matter?
Yes.
Do you have any witnesses, Mr. Asper or Shea, other than yourselves?
No.
No.
Do the defendants have any witnesses other than themselves?
No.
Not at this time, no.
Okay, then everyone raise their right hand, please. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
I do.
I do.
Thank you very much. Mr. Shea or Mr. Asper, or which one of you or both of you putting on the case for the plaintiff?
We would be co-plaintiffs, Your Honor.
No. Are one of you speaking or both of you speaking?
I believe I was going to be the speaker. Yeah, Mr. Shea.
Was that your understanding, Mr. Shea?
Yeah, can we both speak though? Is that possible if I need to?
Okay, this is what's gonna happen. This is why I'm
Okay.
asking. If there's an
Okay.
opening statement that plaintiffs want to make, this is when we'll take it. So for purposes of opening statement, are one of you speaking or both of you speaking?
I will speak, Your Honor.
Yes,
Okay,
that's fine.
and then what will happen is we'll go to the defendant's side. And if one of them wants to give an opening, we'll take the opening. Not testimony yet, just the opening, what you intend to prove in this case. And then if there's testimony, everybody's already been sworn in, you'll provide your testimony, and then there'll be cross-examination. Okay?
Yes, Your Honor.
That being the case, Mr. Asper, is there an opening statement that you would like to make at this time?
Yes, Your Honor. Short one. The defendants have stayed at the property without paying rent for over 2 years. During this time, there have been multiple ordinance violations, which have resulted in tickets for Mr. Shea. And the defendants haven't even paid the water bill. So the water bill has gone onto the taxes. The failure to pay enough is the reason for the amount and the demand side. I did do a request for a default regarding the demand, but there is no lease in place. So we are wanting repossession of the property. No lease in place. There is case law on this, Frenchtown Villa versus the Meadors. There's no lease in place. So there's no counts. There's no chance of a retaliatory eviction. There's nothing else. We just want the place back, Your Honor.
Anything else, Mr. Asper?
That is all.
Thank you. Mr. Kilgore, is there some opening statement you'd like to make?
Yes, Your Honor. I'd like to start by saying this is not a simple non-payment case. Mr. Brent Shea and I have a history where I worked for him, and I have done other work for
Your
him.
Honor, this is
fixing up
testimony.
Excuse me.
I object.
Excuse me.
Your Honor, he's going beyond the scope of this is just he's giving testimony, Your Honor.
You're explaining why.
Mr. Asper, please don't interrupt him.
I apologize, Your
I
Honor.
heard your objection, but it's opening. Mr. Kilgore, please proceed briefly.
Okay, so when I first talked to Brent about the house, it was on Facebook, and we agreed later. We had a verbal lease agreement to work on the house and that would be towards rent. Now, when I moved in the house, he had already owed a sum of like over, I think it was $3,000 to $4,000 in back taxes. So even though the house was not in any kind of livable condition with no, CO permit or anything like that, I still when COVID first started, I still decided to move in anyways, give him the $3,000 or $4,000 to pay the taxes, which he didn't pay any taxes since I've lived here at all, I found out. But I also paid him, and I have proof of that too, an excess of up to $10,000 on top of that every time he requested it. So, but the whole point of what I was saying is that our agreement wasn't for like month to month thing, paying a certain amount every month. Our whole thing was I stay here, fix up the property instead of paying the rent. But the reason why I paid the money when I moved in was to pay the taxes,
Portion of it.
and then for a long
No, wait, no, ma'am, either you can speak or he can speak, but when you speak like that, it causes him to break up.
Okay,
So,
sorry.
This
sorry.
is just, no, it's okay. This is just the opening statement, your response to the complaint, and then we'll take testimony from Mr. Asper and Mr. Shea, okay?
Okay, and then also, Your Honor, I mean, he hasn't been out here to see that the type of work that we've done on the house since to even show, like, I have messages where I'm trying to contact him to say, hey, listen, can you come out here? Can we get a lease going? Like, I can't just keep paying you money whenever you want, and then you're not taking anything off for these repairs. You're not the only time I heard from him was when he wanted money. And I got to a point where I'm like, I'm not going to just keep giving you money and you won't even give me a lease. You still won't get the CEO for occupancy in the house. You won't do any of that. And I just was at a dead end with him. I wasn't sure what to do. So, and then we did speak to him. It went about 2 or 3 months.
Mr. Kilgore?
Yes.
Okay, so your defense of the complaint is that you've done work on the property and you had some agreement as to how you would occupy the property, correct?
Yes, Your Honor. My
Okay.
defense is that I didn't. He's trying to say I owe him $25,000 for monthly rent, and I never had any agreement for a set amount for a monthly basis. The agreement was to stay there and to do that, and then we would work it out. He said once everything got good and then we could, maybe he even told me maybe I could even purchase the house on a land contract or something of that nature.
Oh,
we did talk about
Mr.
that.
Kilgore, I'm going to
Yes.
stop you at this time.
Okay.
Mr. Asper, your first witness.
Yes, Your Honor. My first witness will be Mr. Brent Shea.
Mr. Shea, you're under oath. Your first question to Mr. Shea, sir.
Hello, Mr. Shea. Could you give your full name for the record, please?
Brent Edward Shea.
Yes, Mr. Shea. When approximately how long ago did you first interact with the defendants?
The first time I interacted with them?
Let me rephrase that question.
Sorry.
About approximately how long ago did the defendants start renting the property?
It was May of 2020.
Okay. During that time, did they make a first month and a security deposit?
Yes.
Do you remember what those amounts were?
It was the money that he is stating that was for taxes, which is a complete lie. It was a deposit in first and last month's rent, and that was it. That was what
Okay.
that was for the first time.
That's enough. When did they stop paying the rent?
It's been
Approximately.
over 2 years. It's probably the last time they paid anything was the summer of 21.
Okay. The defendants, as we were listening, they said that it was a verbal lease. Is that correct?
I mean, yeah, at that time, yes.
Thank you, Your Honor. That's all for him, from this
Yeah.
witness.
Your Honor,
Thank
can I,
you.
sorry.
Can you what, Mr. Kilgore?
I just wanted to interject and say, am I allowed to say anything in defense of that?
No, no,
Okay.
make your notes.
Okay.
What you're allowed to do is ask Mr. Shea questions. This is not testimony, this is questions. Do you, on behalf of the defendants, are there questions for Mr. Shea?
Yes, Your Honor. Yes, Your Honor. The first question I have for Mr. Shea is, my mind is going blank. When we moved in and we gave you the money, was there someone else living in the house at the time?
Nobody was living in the house at the time.
No, so nobody was
The
living
water,
here.
the water wasn't even on.
The water wasn't even on.
The water was not
I would
on.
object, Your Honor, for foundation.
Okay, well, what I'm trying to show is the character of Brent and how he's done this before and how he has made other agreements with prior people and did the same thing. And I think
Your
that
Honor,
Then
Okay.
Mr.
Object.
Asper, no.
I apologize.
Mr. Kilgore,
yes,
these
yes.
are, I'm going to tell you again, these are questions. If you have questions for Mr. Shea, you ask Mr. Shea the questions. If you want to testify, you'll have an opportunity to testify after the plaintiff is finished with their witnesses.
Right.
My answer is no to the question.
Okay. Do you have any questions? Okay, no questions at this time.
No other questions for Mr. Shea?
Not at this time.
Thank you. Mr. Asper, do you have any redirect for Mr. Shea?
No, I don't, Your Honor.
Thank you. Mr. Shea, thank you for your testimony. Do you have any other witnesses, Mr. Asper?
No, I do not.
Is there any testimony you'd like to give in this matter?
Yes, Your Honor. I would like to give testimony. So as Mr. Shea, some of it I will be reiterating. The defendants lived at the property. They have not paid rent for over 2 years. Regardless whether rent has been paid or not, as the defendant stated, there is no lease in place. The defendants admitted it was verbal, and that was the same with Mr. Shea said. Michigan law states that verbal agreements are month to month when it comes to rent. We're just wanting a repossession, Your Honor.
Anything else, Mr. Asper?
No, Your Honor.
Mr. Kilgore, are there any questions for Mr. Asper?
For Mr. Asper, what interest do you have in the property?
Yes, Mr. Shea was a worker of mine, and he told me about his properties, and we agreed to do a land contract. He's not very savvy with the court stuff or being a landlord as I am. So we agreed to do a land contract.
Okay, so I just want to make the record clear if we're dealing with you or with Brent, because I wasn't sure at first. I thought you were his attorney. I didn't know who you were. Okay, and then also, so then just to establish, Brent he is on the deed and you're not on the deed?
No, I did not say that.
Oh, okay. Okay, so you are.
I didn't say that either. We have a land contract.
Okay, so a verbal land contract, correct? You have no documents to show proof of your land contract, right?
The land
Is that a
contract-
question, Mr. Kilgore? I'm sorry.
You're good.
I'm sorry, I just don't see how he can set a land contract with somebody while he currently has a renter renting.
Your
And then
Honor,
also-
my response to that is that rental properties are sold all the time with renters in there. I have
Okay.
63 rental units.
Okay, also.
I'm sorry, but sorry, I interrupted Mr. Kilgore's question, Mr. Asper. His question to you was, is there a written land contract? And your response to that was?
No, we do not have a written land contract. It is all verbal.
Okay, so
Well,
what,
no, let me rephrase that. We do have written, but it's via text message.
okay, so
but-
it's similar, I'm sorry, are you done? So it's
That's all.
similar to the same type of thing that I have with Brent then, correct?
I don't
No.
believe so. You have a verbal lease with Brent, or had a verbal lease with Brent.
Yes.
Brent and I have text messages
As do I.
regarding our land contract.
Okay, and then also, are you familiar with steps and procedures for evicting people?
Very much.
Okay, and did you follow all the processes, including like the notices to quit, and you did all that? You did
I
all that
did.
right by the book.
I did.
Okay, so the first notice that I received, or actually I received two notices at the same time, but this notice, do you remember? Do you recognize this? Oh,
It's not showing me because your
Yeah, I'm
thing is
looking.
yeah.
This would be the notice that says, notice to quit to recover possession of property, landlord tenant. And it says that I certify on 9/1/2023, I serve this notice on occupant name. And then it has Brent Shea's signature, and then it has your signature, and then it says your landlord, landlady, Brent Shea, William Asper, is seeking to recover for that. Okay, but it has no case number, no judge. Like I said, I'm sorry, I'm not finished. I'm sorry.
I'll answer. No, I'll go.
Okay.
I know where you're going with this. So, the procedure with this is the notice must be given first, whether if it's a 7-day, a 30-day, or a 24-hour. So that's that notice that you have.
Okay,
At that
thank you.
time, hold on, I'm not done. At that time, there is no case.
Excuse
filed.
me. No, you are done.
Okay,
You
I
are
apologize.
done.
Ryan. I apologize, Ryan.
You are done. Mr. Kilgore, your question.
Okay, and then Mr. Asper, did you serve the paper that is the notice to quit to recover possession of property? Did you take that to the inhabit and take it to the court and did they see it? Or I mean, because what I'm trying to get at here is when you sent this one,
Yes.
you sent this one at the same exact time. And it says that I had to appear on 10/1 and you sent it on 10/30. So how was I supposed to appear to get my fair chance to say, hey, what's going on, or dispute anything? Like, you just rushed the process. And the reason I'm asking the question, Mr. Asper, is because I'm trying to figure out what was the big rush here. And
Mr. Kilgore,
Your Honor, this is
Mr. Kilgore, I'm trying to allow a little leeway because you're representing yourself, but this cross-examination is questions. If you have
Right.
questions for Mr. Asper, and if the issue is that you may not understand the process, you asked a question about the notice doesn't have the court date, the court case number on it yet because there's no case filed. Some people get served a notice and they move from the property, or they pay the back due rent, or they clear up whatever the health hazard is.
right.
So then
okay,
your
yeah.
next question is, why is this process rushed? And the process is not rushed. This case has been pending now for at least 3 months.
3 months at least. And
So,
that's the second
Mr.
case.
Kilgore, if you have questions, you're welcome to ask your questions. But if your issue is that you're trying to testify to put your defense on, it might be better for you to get to that part of the case. So if there are questions,
One last question, Your Honor. Actually, you know what? No further questions at this time. For
Thank
Mr. Asper. Go.
Mr. Asper, is there any statement you want to make in response to the questions that Mr. Kilgore just asked?
I'm not really sure he asked too many questions. This case, there was 2 cases. One, I believe I may have missed and it was dismissed. This has been going on for at least, I believe, 3 or 4 months. There was no rush on it. And the notice, of course, the notice doesn't have any sort of case number on there because it hasn't been filed yet, Your Honor. That should clear up everything.
Okay, may I ask one more question, Your Honor?
No, you're not supposed to, Mr. Kilgore, but if you want to, if you can keep it brief.
Okay, yes, Your Honor. Your Honor, Mr. Asper, is the house, as you know it, in foreclosure?
Currently the house is in tax foreclosure. I believe it owes a back of about $16,000 or $18,000. But that's going to be remedied
Okay,
with the county.
all right, that's all at this time, Your Honor.
Thank you. Mr. Asper, are there any more witnesses or documents on behalf of the plaintiff?
The only documents I had, which I provided, was the multiple water bills that had not been paid by defendants. So even if there was this agreement between them, the water bills had not been paid. That was the tenant's responsibility. There was the junked vehicles in the parking lot, which resulted in tickets for Mr. Shea. And again, what the defendant has stated multiple times now, verbal lease which is month to month. There was no paper. So I mean, I would request summary disposition, Your Honor. Thank you.
You're welcome. Mr. Asper, your request for summary disposition is denied. Mr. Kilgore, your case, sir, your first witness, sir.
Your Honor, I'd like to call Brooklyn witness, or Brooklyn Manchieski as a witness. And I'd like to ask Brooklyn, are you aware of Mr. Shea having was Mr. Shea when you moved in the house, since he said the 4,000 was for security deposit instead of the taxes, then was the house livable? I mean, was there siding missing on the side of it? Was it?
No, the house wasn't livable. The garage was falling apart. The whole half of the other house was missing siding. There was black mold damage throughout the whole entire house. There was a hole in the ceiling. There was a lot of damages that needed to be repaired before anybody else could even move in.
Okay. And also, was you there when I asked when Mr. Brent Shea and I talked about the agreement about working and paying off the rent, and was you a witness to that?
Yes, I was there when we talked to him. We met with him, and we both needed help. We helped him. We gave him the money. It was supposed to be for his taxes because he owed back taxes, and we told him, well, we can do work on the house because it needed work. There was also a previous person living here that was supposed to do work on the house as well, and it wasn't done.
Okay, and did you move them? Did you help move them out?
Yes. When we first moved in, we had to move the previous tenant who was staying here out of the house so that we could move in.
Okay. And
also the garage, we moved everything out of this house was very unkept premises when we moved in. The garage was full to the ceilings. Like that's where I think the tickets came from the beginning of the unkept property.
I'm sorry, Your Honor.
And what paper did you find on the door when we moved in? What did it say?
The CO, that it couldn't be occupied.
That this property couldn't be occupied. And when we asked Mr. Shea about that, what did he say?
He said it was taken care of.
He said it was already taken care of?
Yes.
Okay. And you found out though, didn't you, that it wasn't taken care of, was it?
No, it wasn't.
Okay. And that'll be it for now, Your Honor.
Thank you. Any cross-examination, Mr. Asper?
Yes, Your Honor. Of course. Can you repeat your name for the record, please, ma'am?
Brooklyn Manchieski.
Manchieski. Can I just call you Brooklyn just to be short?
Sure.
Oh, okay. Brooklyn, how much was your monthly rent
Our
at the
monthly
subject
rent,
property?
we really didn't establish a monthly rent because we were actually doing repairs on the house. So when we moved in, it was, if we had to pay rent, it was $1,000 a month. But prior to that, he told us that we shouldn't have to worry about rent. Just do the work on the house and save up your money. And then between that, we could do a land contract because this house was in disarray when we moved in. Also, he had us do other work on another property that he lost in this neighborhood.
Since you brought it up, what is the address of that property,
Um,
if you know?
on Orchard Lane, I know that one. On Orchard Hill, I do not have the exact address number right here. I mean, I can get it.
No,
but
no,
I-
no
it's on
need, no
Orchard
need.
Hill. It was the
No
first
need.
house that we looked at because he had two houses he was offering us and he wanted us to live there to do the work or this one.
I understand. So my next question, when was the last time, either one of you paid rent to Mr. Shea?
It depends on what you refer to as rent because
When-
also, can I talk?
Yes, I apologize.
Also, we also filled out the SIRA application for the back pay of the rental agreement of the last portion during COVID for him. And he never sent any type of lease to them for us. And that's why that was denied. That's why there's a portion of the years that wasn't paid because everybody was off work. That was supposed to be taken care of. But since he didn't send in the right documents, even though we did, it didn't go through for him. And
Okay.
that was the last time that I spoke to him.
My next question, whose responsibility is it for the rent, to pay the rent?
It depends on what you consider rent because we didn't have an agreement of a month, like a month to month. It was you do work and then we'll let you know how much, this is to go back with that. Like we were supposed to, we were paying money to him to help him out, but we never get, like we were never able to, charge him for our fees or what we did on the property because we couldn't get a hold of him half of the time.
All right, so Mike, here, I guess I'll cut this short. So you stated there was no certificate of occupancy on the property, is that correct?
Yes,
So why did you both choose to live there still?
because Brent told us that it was fine. It was taken care of. He said that
Okay.
that was old. He told us that was old.
Okay, so again, my question was, when was the last time either of you physically gave Mr. Shea money for rent,
Mm,
approximately?
I want to say March of 2021.
Okay, and this was a verbal lease, correct?
It wasn't a verbal lease as of to rent month, like with a payment every month. We were supposed to,
Didn't you answer that already?
I thought I already answered that. We are supposed to, we gave him the money at the beginning for his taxes.
Your Honor,
because
no
he
more
needed it.
questions.
Okay.
Thank you. Mr. Kilgore, do you have any more questions for, any redirect for Ms. Majewski? Maneski,
Manchieski.
Majewski.
Brooklyn. How many times did Brent come out to look at the property and see the repairs that were done on the property?
Not once. The last time he was here and physically inside the house was when we moved in, which was in, I think, May 16th was actually was the last time when we met him here and gave him a payment on May 16th of 2020 was the last time he was in this house.
Okay, and so when you was paying him this after, not the first portion when you moved in, but when he kept asking you for money, did you ever stop to ask him what was going on with the taxes and maybe possibly was the house going to be foreclosed on?
Yes, because I kept getting the yellow notices that the taxes were due each year, and he assured me that he was taking care of them, that there was no back taxes or anything like that. So then after I received the court date for this hearing here at the beginning, the next day I received the tax notice on the door stating that none of them had been paid.
And what did that notice say the hearing date was?
February 22nd,
Of what year?
2024.
Okay, and what options on the paper does it say, Mr. Shea has to set up a payment plan or anything? What were the options? Seeing that he doesn't live in the house and he's not an option.
Your Honor,
Mr., I'm
leading the-
sorry,
leading the
Mr.
witness.
Kilgore,
Yes, Your Honor.
I'm interrupting you for different reasons. Mr. Asper has objected, finding the questions is leading.
Okay.
But Mr. Kilgore, I'm trying to get you back to your opening statement indicated that your defense to the complaint was that you had agreed to do work on the premises in lieu of rent.
Yes, Your
And
Honor.
although the tax is,
Sorry, I didn't know you weren't finished.
go ahead.
Yes, it was to do work on the property and work on his other property as well. I didn't say that before. I wanted to make that known now. And it was on, I don't know the exact address, but I know it's on Orchard Hill. It's in the same neighborhood as this house. So we're supposed to do
Mr.
work-
Kilgore, where I'm going with this is you're asking about taxes.
Yes.
And I don't know what taxes have to do with repairs in lieu of rent. So I'm just saying,
Right.
get to what the defense is.
Okay, the reason why I was asking about taxes is because all of the options for him to be able to keep the house, there's only one, they all say you have to live in the house basically. So this would be a reason why he didn't want to do a lease, because then he couldn't say that he lived in the house.
Your Honor, objection.
Because I couldn't find out why he wouldn't give me a
It's
lease. He kept asking
speculation.
for money and I'm like, why won't you give me a lease? I don't wanna-
Mr. Kilgore,
Yes, sir.
I'm sorry, once he says objection, you have to stop. What's your objection, Mr. Asper?
Speculation, Your Honor. There's no proof of anything he's saying, nor does it relevant to this case.
And
Oh.
Mr. Kilgore, the court will agree with Mr. Asper. I'm asking you for your defense. I'm not saying that you have to stop questioning Ms. Majeski. What I'm saying is get to what your defense is on this termination of tenancy case.
Okay, I have nothing else, Your Honor, at this time.
Thank you. Mr. Kilgore, did you anticipate testifying this afternoon?
Yes, Your Honor.
Your testimony, sir.
I'm sorry, I thought you were asking if I anticipated it prior to the courtroom.
I'm saying, are you testifying this afternoon? Is there a statement you want to make in this case?
Okay, yes, yes. Okay, so I'm sorry, I'm just not exactly sure how this goes, Your Honor. I've never
No,
done
this is, Mr. Kilgore, I understand. What I'm asking you right now is whatever it is that you want to say regarding your defense to this complaint, this is the time to say it. Because you're representing yourself, it's not a matter of someone asking you questions. It's a matter of you telling me what your defense is and presenting any documents, evidence that you want the court to consider for your defense. But you may
Okay.
start talking now.
Okay. All right, so yes, in my defense of that, first of all, they said that they haven't had any rent since February of 2021. That's cash rent though. But to my knowledge, that is 2021. But what about all the work that I done? What about everything? You know what I mean? Like, why are you shaking your head at me? Yeah, Your Honor, all I'm trying to say is that I've done lots of repairs on this house that exceed well over what I that he's even trying to say that I owe him. And that's it. Nothing further at this time, Your Honor.
Thank you. Mr. Asper, do you have any questions for Mr. Kilgore?
Yes, Your Honor, very briefly, Your Honor. Mr. Kilgore, again, I will ask you the same questions I asked her. When was the last time the two of you, either of the two of you, paid Mr. Shea rent physically? Not working on the property, physical rent, money, cash.
March 2021 was the last time he asked me for cash and I gave it to him.
Okay, Mr. Kilgore, during your duration at the property, has there been any ordinance violations for, say, a junk car?
Not that I ever received, no. I know that, I will say that, Brent did mention one time about, a vehicle, but I told him that it was taken care of and it was immediately after, but as far as there was nothing here. I know there was previous, my wife was able to find that there was previous, ordinance violations that were before we got here, but it wasn't after we moved in. No, I got no notices after, March of 2020 when we moved in.
All right, one last question, Mr. Kilgore. Brooklyn stated there was no physical lease in place. Is that true? There was no physical lease?
Well, we don't have a drawn out lease.
No more
but
questions, Your Honor.
There
Thank you.
is, I'm not finished. We do have an agreement on Facebook, and we're prepared to show it today if we need to, where it says, we're gonna work something out with working on the house. Basically, it gets to the point of that.
The one more there.
Yeah, he said he's names more than one thing that he needs done on the house.
No more questions, Your Honor.
Thank you. Mr. Kilgore, this is typically the time where there would be redirect, but because you're representing yourself, you can't ask yourself questions. Is there anything else that you want to say in this case? Anything that you want the court to consider?
No, Your Honor. No. Nothing else.
Thank you. Any closing statements by Mr. Shea or Mr. Asper?
Yes, Your Honor, very briefly again. So this is a landlord-tenant case where the defendants and the tenant and the landlord did not have a lease. It was a verbal lease. Michigan law states that all verbal leases are month-to-month rent or month-to-month leases. There has been no physical rent paid since, I believe they said, March of 2021. There have been ordinance violations. There's been unpaid water bills. Again, Your Honor, for all of this, and the case law would be Frenchtown Villa versus the Meadors. It was an appellate court case. We request that this honorable court rule in favor of the plaintiffs and for possession of the property. Thank you. Plus the money judgment, Your Honor.
Thank you. Mr. Kilgore, any closing on behalf of the defendants?
I guess I'm just wondering why Brent never signed a lease or never would come and get a hold of us, never contacted us, and went months without contacting us if he was so-called trying to get this money that I owe him. Why didn't he come to the house where we're at? He knows where we live.
I did.
You did?
No, this is not a time for you to talk to one another.
Okay.
Sorry.
But that's it.
Mr. Shea, was there something you were trying to say, or you were just interrupting Mr. Kilgore?
Yeah, I'm sorry, Your Honor. My apology. I'm sorry.
No, was there something you wanted to say, though?
No, thanks. No, thank you, Your
Okay.
Honor.
The court has had the opportunity to hear the testimony of the parties, and no one has presented what it was that started this landlord-tenant relationship. There's testimony, but there's been no evidence of it. Mr. Asper has been clear and accurate in stating that these were by default a month-to-month tenancy. The court has reviewed the filing in this matter, and attached to the complaint in this case was a notice to quit that provided the tenants with 30 days notice to vacate the property. There's been no testimony that that notice was not received or that there was some defect in the notice. So the court is finding that that 30-day notice was proper. This case is a termination of tenancy case. Although there's some testimony and conversation regarding rent and when rent was last paid and repairs that might have been done to the property, there's been no evidence received that would support a $25,000 money judgment in this matter. In this case, the court will find that the plaintiffs are entitled to possession of the property. There is no money judgment being awarded at this time. The court is making no finding regarding any amount that might be due and owing from the defendants to the plaintiffs or any offsets due to the defendants for any work having been made on the property. The court is treating this purely as a termination of tenancy case, finding that the notice to quit was valid, finding that the plaintiff has met its burden in this matter. Mr. Shea or Mr. Asper, please present a judgment to the court that indicates that the plaintiffs are entitled to possession of the property. Is there anything else, Mr. Asper?
Yes, Your Honor. The money judgment part, I understand. As far as the costs, though, the filing fees, are you awarding filing fees and process serving?
Plaintiff is, the prevailing party is always entitled to those
Just wanted to
reasonable
make sure.
court costs. So whatever your filing fee and service fee were, you may include them in your judgment.
Thank you, Your Honor.
Mr. Shea, is there anything else?
No, Your Honor. Thank you.
Ms. Majeski, anything on your behalf?
No.
Mr. Kilgore, anything else?
No, I guess, is there? No, that's it, Your Honor.
Thank you. That concludes this matter. You're free to go. You have a good day.
Have a great day, Your Honor.
Thank you, Your Honor.
Thank you. Mr. Stewart, please remove your cap. I have not seen Mr. Katz this afternoon. He was present for an earlier case. Have you had some contact or communication with him? He's here now, Mary Ann. Thank you.
Hello?
Thank you, Mr. Stewart.
Okay.
This is 2302327 LT. This is the Maxwell versus Clarence Stewart. May I have your appearances, please?
Good afternoon, Your Honor. Sidney Katz on behalf of plaintiff.
Mr. Stewart, please state your name for the record.
Clarence Stewart III.
Thank you. Today is the day and time set for hearing on the defendant's motion to set aside the default judgment in this case. Mr. Katz, the court did not receive a written response from you. Would you like the opportunity to speak to Mr. Stewart, or are you prepared to proceed with this motion?
Well, Your Honor, we haven't received any payments since the judgment date. I mean, there's $5,600 currently owed. I mean, he indicated.
So
that he
I'm
needs more
sorry,
time
Mr. Katz?
Yep.
Mr. Katz, just so we're clear, your answer is no, you're ready to proceed with the motion.
I'm assuming yes.
Thank you. Mr. Stewart, this is your motion, sir.
Yes, I apologize. I didn't know that I should have made more payments. I would have made more payments. I just didn't know how this proceeding was supposed to go. So I am prepared to make payments to the Maxwell. I can talk to them today. I just needed a little bit more time because, you know, we were on that strike and I got a little behind. So I just needed just a little bit more time, but I will talk to the Maxwell today once I get off for an additional payment of maybe this month or whatever I need to do. And I just need a little bit more time for the remainder just to catch up a little bit. We have been back working for about a couple of weeks now. So I'm putting a lot of money aside. So I just need to catch up, and I will definitely take care of everything because I've been there for a very long time. And so I do want to try to continue that. I don't want to mess up the relationship I have with that complex.
Mr. Stewart, before Mr. Katz responds, the court's issue was that you filed this motion to set aside the default judgment, indicating that you needed more time to pay and that you were behind because of the strike.
Yes.
The motion that you filed does not address your failure to appear for court on December 15th or on December 1st. So the court's looking for an explanation for your failure to appear on the court dates.
I apologize. I had the unemployment. I was supposed to receive unemployment, but it got messed up. Ford's always messed it up. So I had a lot of like bills and a lot of this mail. I assure you, it just got lost, and I didn't see it until like it was really too late. I apologize for that.
Mr. Cass, is there anything you'd like to say, sir?
Well, Your Honor, this is a motion to set aside default judgment, which was actually submitted to the court after I think the writ was actually filed with the court. I believe that there's a writ that's already waiting with the court on this. It was filed, the motion was filed well after the required time period, and as you indicated, Mr. Stewart really didn't put a meritorious defense as to why the judgment should be set aside. At the same time, there's a significant amount owed, and if my client is willing to work something out with Mr. Stewart, that is okay with me, but as I indicated, the balance currently exceeds $5,000. I'm trying to get the exact amount. Current balance is, as of today, $5,862.
If it would be okay with anyone or the complex, I will try to talk to them if it's okay, and I will.
Yeah,
be
they
able
can,
to-
any arrangement they want to make with you is okay with me, but I can't force them to do that, nor
I
do I believe
understand.
the judge has that right. Your Honor, at this time, requesting that the writ be signed. And again, if my client's willing to work with Mr. Stewart, he's been a longtime resident, he indicates. I hope they can work something out.
Anything else, Mr. Katz?
I believe that there's an escrow posted with the court, requesting that the court release that to my client, and that would be applied to any balance that he currently owes. At the same
Anything else,
time,
Mr. Katz?
what? Just one last thing. At this time, the judgment amount is less than what is currently owed. Judgments for 43.55. He owes 46. I'm sorry, 58. So just we got January rent due as well. So that's it.
Thank you. Anything else, Mr. Stewart?
Yes, that's what I'm not sure what all that means. I did pay, they told me to pay a month's worth, so I don't know if that goes towards it. Also, the 56, and like I said, I think that would bring it down to within like 3,000, possibly, maybe the early 4,000s. I can try to have at least 2,500 by tomorrow, and Friday I can finish that off. I just needed a little bit more time to take care of that. And as I stated, I didn't know if they wanted me to put down a little bit more when I did the escrow. I would have, but they only said to put down a month's worth, which I just thought that would satisfy any of the parties. So I do apologize for not moving further with any of the more money transfers.
There's no need to apologize, Mr. Stewart. The motion to set aside the default judgment requests that 1 month be posted, and that's why the court staff has you post 1 month. This was the defendant's motion to set aside default judgment. The court will find that the defendant has failed to set forth good cause for failing to appear for the hearings that were scheduled before this court. The court will further find that the defendant has failed to assert a meritorious defense to the underlying non-payment of rent case. At this time, the motion will be denied in its entirety. The escrow that's on deposit with the court, $1,300, will be released to the plaintiff. Mr. Stewart, I'm not sure if you understood, Mr. Katz was saying that he is not authorized to enter a payment plan to the balance that remains due and owing in this matter, but you can speak directly with the staff at the Maxwell. You've already indicated that that is your intention, that you have funds available to pay tomorrow and more by the end of this week. Mr. Katz, if there is an application for writ pending, I don't recall having seen it, but I will review the matter and we'll sign the writ on Monday, the 29th, unless we received indication from your office that there's something else, some other way you'd like to proceed.
Okay, that sounds reasonable, Your Honor.
Is reasonable? Okay.
Yep.
Mr. Stewart, do you understand what the court just placed on the record?
Not really. I don't know what a writ is. So
It's their plaintiff is asking for you to physically be removed from the apartment. What the court is suggesting is that you go sooner rather than later, and that there is some agreement that you reach with the Maxwell, they will relay that information to Mr. Katz, and he will advise the court not to proceed with the writ. My suggestion is that you move sooner rather than, not move out, but move going to the Maxwell office sooner rather than later, and make sure there's an arrangement in place. The money that you posted with the court will be released to the Maxwell, so that will go towards your outstanding balance.
okay.
Does that make sense, Mr. Stewart?
Yes, it does. Thank you.
Do you have any questions, sir?
I'm with what my outstanding balance is and what will be released, what is the remaining balance?
I think
You
it's
would currently- you would have a
$45.62.
$5,500, 45, yeah, 45 would be your balance.
Okay, so 45 is the balance. Okay.
That's my
46
math,
judge
Mr.
indicated.
Stewart.
Now, Mr. Stewart, Your Honor, even if you were to sign the writ, my client would like not to proceed with any eviction if they've worked out something with Mr. Stewart anyway. So they're pretty reasonable, Mr. Stewart. So I would have that discussion immediately with them.
Okay, I will try to, like I said, we've been back to work. I get off today at 4:30. I'm at work now, so I'm gonna try to leave here immediately, or I try to give them a call as soon as possible. And
Anything
if
else, Mr.
not-
Katz?
Okay.
Oh,
No,
sorry.
Your Honor.
I'm sorry, Mr. Stewart. I thought you were done. You were saying if not what, sir?
If not, then they just remove me Monday.
No, sir. I will sign the order that allows that process to start, but I'm delaying it to give you a little bit of time to get over there and pay the $2,500 that you said you'll pay tomorrow. I think landlords tend to appreciate funds in hand versus promises of money.
Okay, great. That's great to know. Thank you.
Anything else, Mr. Stewart?
No, thank you.
Go back to work, sir. Have a good day.
Thank you.
You're welcome. Mr. Katz, you also have 2302905
Yeah, I'm on my
LT
way.
to Maxwell versus Maurice Reese.
Your Honor, that's an in-person. I'm actually on my way to the court right now. I figured I exceeded my time limitations on a 15-minute wait, so I pulled over to do that Zoom.
Oh,
hearing.
no, I always assume late attorneys will get here eventually. I haven't received communication that Mr. Reese is in the building. So how far are you from here?
I'm by the airport, so give me like 15
I'll see you.
minutes.
I'll see you in about 10, 15 minutes.
All right, perfect. Thank you, Your Honor.
Thank you.
Yeah, it's golden here, isn't it? Yeah, I should just come by here all the time, just so it gets used. Yeah, I know. I mean, there's so much space. It's just like. You know, I haven't seen you in person in a while. One time since COVID. Wow, only once.
Only once what?
When I